Minnesota Workers' Compensation Court of Appeals is resuming session. The Honorable Patricia Millen, Chief Judge presiding.
Please be seated. Well, we're starting a little late today. We have some technical issues, but it seems to me that we have resolved them for the purposes of allowing everybody the opportunity to be heard today and appear at this oral argument. We have here Mr. Alan McKissic versus Bor-Son Construction, AIG Insurance Company. Ms. Atkinson, I know, as I understand it, you represent the employee's brother, and you have brought the action forward on appeal to present the case today, correct? Okay. This is file number WC236528. Today's date is December 11th, 2023. We are live stream. Each party in an appeal has 15 minutes to present their case. You can reserve such time as you feel you believe you need, and make note of that as you step forward to the podium and make your arguments before us. Does anybody have any questions before we begin? Mr. McKissic, this is Chief Judge Millen speaking. Can you hear me?
Yes, Your Honor.
Okay. And we are proceeding today with this appeal, and you're ready to go forward and listen to this case, and I will give you an opportunity to ask questions. Do you have any questions before we begin?
Yeah, I guess I do have questions, like why my attorney quit on me, and
Well, I'm gonna stop you right there. I did receive your email. You had
okay.
questions of that, but that's not part of the appeal before me today.
Oh,
That's
okay.
something outside of this appeal, and you're welcome to pursue those questions in another forum. But today's,
Okay.
we are only addressing the compensation judge's decision regarding the allocation of services provided to you by your brother.
Oh, no. Okay.
So we're going to let your brother's attorney, Carrie Atkinson, go forward first. She'll have 15 minutes. I ask that if you have questions, you can write them down, but you will not interrupt her. She will have the full 15 minutes. And then we'll let Mr. Peterson present his position. And again, he will have a full 15 minutes. You will not interrupt him. And then I will give you the floor to ask any specific questions as it relates to this appeal on a decision issued by a workers' compensation judge on the services provided and the payment for those services. Now, on that case, which is the only case before us today, do you have any questions?
No, Your Honor.
Thank you. Ms. Atkinson, why don't you come up to the podium? Thank you. You may begin.
May I reserve 2 minutes for rebuttal, please?
And I'm going to ask you to speak up.
I'm sorry. May I reserve 2 minutes for rebuttal, please?
Yes.
Thank you. Good morning, Your Honors. It is my pleasure to appear here before you today regarding an important issue. Anthony McKissic is my client. Alan McKissic is the injured employee, and my client rendered nursing services to the employee for quite some time. They were awarded by Judge Pham in her as a result of the February 8th, 2022 hearing. However, my client was not given notice of his right to participate in that hearing as an intervener. The employee in this case sustained severe physical injuries and consequential psychological injuries while engaging in the employer's industry as a brick tender. One of the basic principles of Minnesota workers' compensation legislation is to place the burden of economic losses resulting from workers who are injured while engaging in industry on the industry. As a result, the Workers' Compensation Division established the procedures required by Rule 1415-1100 concerning potential interveners in the late 1970s.
And let me stop you. If I can, I have a question. Now, throughout this, the time period that your client provided the employee services, he was always a resident of Las Vegas, Nevada. Is that correct?
I believe he rendered some services in Minnesota, but then towards the end, the services at issue were in Nevada indeed.
And so the claim or the medical request that kind of started all of this at that time that was filed, and I assume for the period up to the time of hearing, the services were being provided in Las Vegas, Nevada?
Yes, yes.
And then in looking at the order that came out that awarded the employee the healthcare aid benefits, looking at that order, it's awarded, but doesn't say to whom.
Correct.
And it looks like there were things afterwards. So doesn't it just come down to a mistake because the self-insured employer or its TPA just simply paid the wrong person? And in looking at the closing arguments, the parties just seemed to go like, well, it's sure paid it incorrectly. It was a mistake. And everybody seemed to argue, okay, in that case, it's an overpayment. You take it out of the employee's ongoing permanent total disability benefits. I mean, that seemed to be the position. Am I wrong somewhere along the way?
No, you're absolutely correct.
So and that way, there isn't, whether or not your client was given notice or not notice, may not be important simply because he lived in Las Vegas, and all the other interveners who were given notice at the time of the hearing were medical providers. The judge didn't extinguish those because she didn't have jurisdiction over them because they were out of state in Nevada. Why isn't your client, even if, assuming he was given notice, didn't intervene, wouldn't have been in the same position?
He was not given notice of his right to intervene. He participated in the February 2022 hearing as a witness in support of his brother's claim. However, he was never advised of his right to become a party as an intervener, which arguably led to the mistake. The payments were ordered to be made, but not to whom. Had he been granted party status, he would have had the opportunity to argue for himself that the payments were to be made to him. At least he could have spoken up and said, Your Honors, if these services are awarded, please award them directly to me.
In looking at that scenario, though, you recognize that the Adams case allows the employee to go forward with making a claim for medical services. And in that case, the providers of those services, it was like $35,000 worth of services in that particular case, they were awarded the benefits. The employee won, but it was the person who provided, or the entities that provided those services who won. How is that different in this case than in Adams?
Well, in this case, the payments were made to the employee, and the employee failed to pay the provider of the services. So in the Adams case, I believe the providers were paid, yet in this case, the provider was not.
And the record, at least before us, was there any, it seems like there was just some miscommunication, again, a mistake, and we're not blaming anyone. The employee was paid and has made some payments back to your client in the amount of $27,500?
There is some dispute about what that payment was for, but we were willing to accept that that was payment for nursing services that he provided.
And the other question I have, being that your client provided the medical services to the employee, which were awarded, I think there's some discussion other than the $27,500 that's been paid by the employee to your client. who should receive the interest or for those awarded benefits? For
The
healthcare?
employee. That claim belongs to the employee.
You can continue.
Thank you. So in 2005, after the Lundin case was decided, which is, of course, is the case that it's being relied upon by the employer and insurer, potential interveners were specifically defined by Rule 1415-0300. Subpart 18 was added in 2005, and it defined potential interveners as any person who has an interest in a workers' compensation proceeding such that that person may gain or lose by an order or decision.
So this is my question, and this is, it's troubling to me, not as it applies in this case specifically, but in the future. You have a permanently and totally disabled employee. You have a family member providing services. We'll say we accept that your argument is correct, that they are potential interveners therefore, and they should be given notice. And then they are.
Mhm.
And then they don't intervene. Maybe the Adams case protects the payment anyway, maybe not. But the Supreme Court's about to decide some issue that may inform that outcome. But if I'm providing services to my spouse, my sibling, and I get that notice, I might say, what's this all about? And you ask your relative, the injured worker, oh, I don't know, my lawyer's taking care of it, don't worry about it. And the next thing you know, they don't intervene. And that's the fear I have, is that it will the outcome that you're proposing certainly would benefit your client in this scenario, but it might ultimately work to the detriment of several family members in the future providing services. That's my concern. And I don't know necessarily what the right answer is, but that's what's bouncing around in my head. Because I certainly get it. Your client provided something, it was awarded, and then didn't get it. That seems wrong. I get that part. But I don't know if making family members potential interveners is the right answer. I don't know if you have a thought on that.
I believe it is the right answer. In the scenario that you're proposing, that an uneducated or at least uninformed person receives a notice of their notice of their right to intervene, it is upon them to ask, what does this mean? I believe it's the notice, as required by the statute, does list, the documents that are supposed to be attached to the notice and directs you to the website that gives you step-by-step instructions on how to intervene. So in that scenario, it's on that person, the receipt of the notice, to read it and follow the instructions that are attached. And if they have questions, look it up, because the website is provided right on the notice. And if they still have questions, then retain an attorney.
Yeah, and when you're a hospital, a clinic, another medical provider in this state, you probably are used to this, or at least know what to do. When you're the unsophisticated spouse, brother, nephew, whatever, of an injured worker, I'll get around to that, and then the 30 days or the 60 days ticks by, and now they're out. And that also seems wrong, especially if the nursing services should have been awarded, and in fact are awarded, and then the judge says, but insurer doesn't have to pay them because they're out. And now you got a dispute between the siblings, potentially.
Correct.
Where no money's paid. I provided all these services, you won, but I don't get anything, and you don't either. That's my concern.
Right. And in this situation, the services were paid, albeit to the wrong party.
Right. Right, and that seems to be the biggest problem, is the order just says, as Judge Christensen pointed out, pay, and didn't say the who. I know this Judge Patterson's order from way back said, pay the parents,
Yes.
and the parents were presumably paid, because nobody raised anything, so presumably they were paid. So is there a remedy without going to intervention status?
I don't believe so. The simplest remedy would have been to order the employer and insurer to, again, make payment, albeit to the correct party, and then claim reimbursement under the statute by withholding 20% from future benefits that the employee is eligible to receive.
And that seems to have been raised by in front of Judge Pham, the most recent hearing.
I believe so.
Okay, and it looks like, and she said there's no prejudice, and therefore, there's no or I shouldn't say that. She said that too, but I can't remember what she said about there isn't an overpayment, essentially.
Correct. So we never.
Is there any basis for that finding, that there's simply not an overpayment?
I don't believe so.
Okay.
There
I
was
thought
an
you said that the dispute of what the payment was for remained a dispute. Is that an incorrect statement to attach to those funds that were set forward?
Well, I believe pursuant to at least one of many stipulations,
Okay.
that it was stipulated that the employee knew what he was receiving the payments for, yet did not turn them over to my client, the provider of those services. And even after the claims adjuster was given very specific instructions, ongoing payments should be made to my client, Anthony McKissic, the claims adjuster continued issuing payments to Mr. Alan McKissic. So in my view, this is a claims adjusting error, and the burden falls on the employer and insurer to correct that error.
And if I'm following what you're saying, it would be make payment by the self-insured employer and the insurance company to your client, less the monies received, the $27,500, and less the interest.
Correct. The interest, however, was paid to the employee.
But that would be a credit. I mean, your client isn't entitled to that interest. It was properly paid to the employee.
Exactly. It was properly paid to
So-
the employee.
So I'm doing the math. Okay, thank you.
So the Lundin case, which I'm sure we're going to talk about, really has nothing to do with this case at all. Because in Lundin, the provider of the services was the wife of the injured employee, yet the employee had closed out all of his claims, including past medical, by stipulation for settlement.
Ms. Atkinson, your time is up. I'm
Thank
going to
you.
ask my colleagues if they have any further questions.
No, and I do understand your argument on Lundin.
Thank you.
It was in the brief very well.
I have no further questions. Thank you.
Thank you, Your
Thank you.
Honors.
Mr. Peterson? You have 15 minutes.
Thank you. Can I reserve two?
You may.
Rebuttal, please. Thank you. Good morning, Your Honors, Counsel. I want to just address something real quickly. Mr. Ray Peterson always vigorously opposed the overpayment argument, saying the payment was made. So therefore, how can you have an overpayment if everything that the judge ordered was paid? And that was the basis for the judge denying that there was any overpayment, therefore you can't use the
So,
statute.
Mr. Peterson, I'm going to interrupt you at this point and just ask something that's more a question of logistics. When you get a decision, a findings in order by compensation judge, have you not on occasion gone in while they still have jurisdiction, let's say within the 14 or 30 days, and asked for a correction or an allocation, something? I've seen this happen. I've been a compensation judge where the parties have come in and said, can you please identify with specificity who this should be paid to. Was that done here?
No, and in hindsight, I probably should have. I went to the employee's attorney and asked that question. And on May 9th, he specifically said, and that's Exhibit Employer Exhibit 2, that said, here's how much more you owe my client. Here's how much you've already paid, so I acknowledge that you paid him. And then going forward, the ongoing payment should be paid to Anthony. So he specifically said that what had already been paid was fine, going to the employee, and in terms of going forward, the only mistake the claim rep made is they then made 3 more payments directly to Alan when they should have been directly to Anthony. And if there's any right to reimbursement or payment to Anthony, it would be for those 3 payments that are noted in our brief, $1,668 per month. So it's our position that.
Can I ask, so
Sure,
we have
go
this,
ahead.
because in reading through, and it's you, Mr. Peterson, well, the other Mr. Peterson were involved in the Jennifer Patterson decision in the early 2000s. The parents were awarded the benefits at those times. Were those paid to the parents or were they paid to the employee, if you know?
I do know they were paid directly to employees, parents, and 1099s were issued after each year.
And so if you have that, it's not before us, but one of the things that troubles me, and maybe there's more that I don't know about because we only have the record that we have, but there's an award of benefits to the employee, nursing services provided by a family member, his parents. Parents are paid directly. Parents eventually die. Brother steps in. In fact, it looks like the brother kind of stepped in even before the parents passed away. Why is there even a trial on whether or not the employee is entitled to nursing services? That's already been determined, unless there was some evidence that he no longer needed them.
That was the crux of the whole case.
Okay, all
Was
right.
whether
So
or not over 17 years,
he still needs it.
there had been a change in his ability to function and take care
Okay,
of himself.
so, and Judge Pham says, no, he's still, if anything, he might even be worse. I'm awarding nursing services. She didn't say to who. Bad on her, let's say. No one asked her to clarify. Bad on you, bad on you. Okay, who cares who's bad on? But your client was paying the parents. Why didn't you just immediately go, well, then we'll just pay the brother?
Candidly, 17 years. Some of us forget things
Yeah.
and don't remember the history on files. 17 years later, and we're fighting over whether or not today, 17 years later, nursing services are warranted. And we didn't then go to the judge for clarification, but we went to the attorney.
Okay, so can't we just treat this as all of it? Not the interest. We agree the interest goes directly to the employee, but everything else, can't we just treat this as an overpayment under, what is it, 138 or whatever number it is?
179.
178, 179. Can't we just treat this as an overpayment? I know Judge Pham says no, but can't we find that there's no substantial evidence to support that?
Excuse me, my only concern is that Ray Peterson, his May 9th email says, it's okay that you sent the money to my client. And then you go on in the testimony, and I can refer you to it on pages 56 to 60 in the transcript. You know, Mr. Alan McKissic, the employee, received almost $104,000 and has not paid his brother, even though on May 9th, he told his attorney that I already got $80,000, $79,000 something. And so he's made no effort to pay his brother. And then when asked at the hearing, do you have the money? He says no. So I'm puzzled by this kind of a moral obligation, in my opinion, and maybe it's not a legal obligation, but you know, he had the money, it was there. He gets $725 every week in permanent total disability benefits, so.
So I understand, I don't want to step outside the arguments here before us today, but isn't this misdirected payment in effect an overpayment? I mean, there is an answer. The answer is, and it may not be one your client likes, Mr. Peterson, but it is to make the payment and then recapture it on a percentage as you can by statute until such time as it's been paid in full. Is that not something that the parties could explore?
Well, explore, I mean, we've explored this case for 17 years, so.
Well, no, you lost on the nursing services, and I understand that. And when the parents died, as unfortunate, this accident, this injury, and this injured worker remained in the need of nursing services. And when that became apparent through an adjudication or through the medical, you paid the employee with the understanding that he would direct those payments to his brother, but he did not. And so the law still has a remedy here, correct? And that remedy, whether your clients like it or not, would be to make the payment in full and then recapture it on an overpayment?
Well, I suppose in hindsight, that's an interesting argument, but we've made the payment.
I understand
So how
that.
can you say there's been an overpayment when we've already paid everything that was awarded?
Well, I think
Well,
this-
in the sense that you've overpaid, when you pay the wrong party. Let's say you didn't pay the injured worker. Let's say you paid me and you sent me a check for $80,000. I go, sweet, I'm going to go buy a new car or whatever. You didn't overpay it in that scenario either. You paid the wrong person. So, and again, technically, Judge Phom's order doesn't say who to pay, but in all practical purposes, you knew that the brother was providing the services, was entitled to the money. Your client paid the wrong person. And then even after told, pay the brother, as you already pointed out, didn't 3 more times. Another $5,000, $6,000. Yeah.
Right.
So it's an overpayment in the sense that the employee is entitled to money, the permanent total, and you pay them an extra $80,000 by mistake or $100,000 or whatever it is. How do you collect that? I mean, what if your client just sent them $100,000 by mistake because somebody made a mistake on a keystroke?
Well, normally people return the money.
Well, and I agree. I mean, you raised a good point that there seemingly is some moral obligation on the employee. Hey, that's your brother's money. Give it to your brother. And I get that argument, and it's a strong one. But I also get Ms. Atkinson's client position, which is, I was entitled to this money and I didn't get it. Your client is at least able to pay it back and recoup it at the same time, slowly but surely,
Yeah.
assuming the employee lives long enough. and
Well, and
all that.
that's the practical side of
Yeah.
this case with his ill health. We probably will never get the money back. But aside from that problem, Mr. McKissic actually testified at the hearing that he thought this was his money. And let me just find that quote for you. He said, "I thought that was my money for reimbursing me for the PCA," he called them PCAs, "that he had gotten in the past." And that's on page 56 and 57. And when you add that to Ray Peterson's May 9th email, in which he doesn't say you paid the wrong people. In fact, he implicitly said, that's okay, you made payment, thank you for making it in a timely fashion, and here's how much more is owing, and please pay that as soon as possible.
So let me stop you there. If I look at the overpayment statute, and it talks about receipt of, or making payments, error factor law, but it has to be made in good faith. Is there any real question on your client's part that the money that was direct deposited into the employee's account wasn't received in good faith?
It was received at the time as deposited in good faith, but he was asked to return it and hasn't, and says it's all gone, and we don't know why. And that's what puzzles me about this case, is it could easily
But
have been a remedy.
that's a question that we don't have to have answered. I mean, I think the overpayment is the best defense your client has to recapture the funds that they mistakenly did a direct deposit into for lack of clarity or for just lack of technology into the employee's bank account. To me, the overpayment statute is pretty much the only remedy you would have in a misdirected payment. If I want to decipher and chop up the word overpayment, I can basically construct an argument that a misdirected payment, that sum is being paid for services the employee is not entitled to receive because the payments are not for the receipt of the employee, but for the person that provided those services. So if you cut a check that was supposed to go to Blue Cross and Blue Shield or the chiropractor into that fund and into that bank account, that would be a payment over and above what the injured worker should have a direct payment for. It should go to the party that provided the services. And that's what I understand is the problem here, in that the employee's brother did not receive the protections that a potential intervener would receive. And you go back to the statute and say, no notice given, we start over again. But I don't see any protection for your client other than to recapture that overpayment under the statute.
And maybe I've missed something. I'm not aware of any appellate or precedential case that says the nursing services go directly to the person who provides them.
Well, the statute says.
Well, the parents
statute
got
says-
it. The parents got
The
it.
statute says every benefit, and that's what the Lundin case really stands for. Every benefit is the employee's claim.
Right.
But when Mr. McKissic, the employee, goes to the doctor, you guys don't send him a check. You send the doctor a check.
Yeah, but he's not a medical provider.
Well, he's not a medical provider,
Dean
but
has said
but the
that.
nursing services are considered medical benefits. They're not any other benefit.
But they're not recognized, those that provide it are not recognized as a medical provider.
So that means that they should be less protected?
No, I'm just saying the law doesn't say any place that nursing services that are awarded are paid to the family member. I'm not aware of any case law that has said that. And because it's the employee's claim, they have a right to bring it. And what they do with the funds, that's their choice. There's no appellate decision that says you must pay the family member. That's why under Lundin, as well as Ray Peterson's email instructions, are consistent with the fact that the money goes to the employee for past services.
Well, it begs the question though then, why did you even ask him in the first place where to send the money?
Because I think there was confusion
Right.
between his office and mine. There was never any confusion between Anthony and Alan.
Yeah, I understand
That
that,
was
but
never an
I understand that, but there, you directly or your client, where do we send this money? Let's ask Ray. And so you did. That's good lawyering. But your client has already sent a big check before he asked the
Oh,
question.
yeah, comply with the 14
Did you
days.
send the check before the 30 days for the appeal and you didn't try to get some type of clarification from the compensation judge? It just seems to me, and in the past practice, you're cutting a check directly to his parents. I don't see how your argument that you're not required to do it by statute would basically continue at a higher level to say, you've made the payment and you have no responsibility to make sure it gets to the correct entity, whether it's a chiropractor or his brother.
I think you know our position.
Yeah.
Yeah,
And
okay,
so my time's up. So unless you have more questions?
No,
No.
thank you.
thank you.
Ask your brother?
I'm getting to him.
Okay.
Mr. McKissic, you're still on the line?
Yes, Your Honor.
Okay. You have 15 minutes to present your position. You are representing yourself, correct?
Yes, I am.
Okay, and would you like to go forward today and present your position?
Yes, the best I can. This is new to me. Well, I guess when I had nothing in writing, nothing nobody told me that, hey, there's going to be money in your account and this and this and that, you pay your brother. I just looked up and it was money in my account, and I'm thinking, well, this is owed me for something. And weeks and weeks later, they found out when my brother, and just when they went to fight about it, that, well, you need to pay your brother the money back. They went through my bank accounts and this and this and that, and try to get me to agree to pay him back $200 a week. And it's just been one ordeal after another. It's just like they just taking me through the ringer with this. And 1 minute, my lawyer, he's retired, and then he comes out of retirement, and then he retires. I just don't know where to go with this. I don't have an attorney now. It's just, I can keep going on and on and on. I don't know where to go. I really don't.
You've had an opportunity, I believe my court referred you to the ombudsman at the Department of Labor and Industry, correct?
Yes.
And you've had an opportunity to speak with her regarding this situation, correct?
Yes, ma'am.
Are you saying that you are in search of an attorney as we are here today to argue
Yes.
this case before you?
Yes, I am.
Okay, and how much time do you need to get an attorney?
I'm just having no luck at getting an attorney at all. Nobody wants to handle this case
Mr.
because of
McKissic, do
that.
you believe that you were rightfully given those payments that were for your brother's services to you? That's a correct analysis that you have in terms of those payments were for you and not your brother?
Exactly.
Okay, can you tell me why?
Because they never sent me notice of what to do with the money. It was just sent in my account.
Okay,
Like, this is
but-
your money.
right. So now they've sent you notice that that money was erroneously put into your account and it should have gone to your brother.
Uh,
Is that correct?
Excuse me?
You now have been given notice that that money was not a direct payment for you, but for the nursing services provided by your brother, correct?
Yes, that was way after the money was gone.
I
And
understand.
it's like they put the money in an account for us to go away peacefully. And then
So are you
What?
saying that you have a legal argument you'd like to put before us today? Or would you like the opportunity, I can hold this case open for a certain period for you to get legal counsel, but I can't hold.
I just want this, I want it to go away. I mean, it's like, I'm in the hospital right now as we speak because
That's correct.
it's blowing my blood pressure up. I mean, I've been in the hospital for 5 days now. They finally got my blood pressure under control. This stuff is just, it's beyond me. It's too much. It's killing me.
I'm sorry. And I would like to say, we want to make sure that you feel that you have had the opportunity to be heard and that you're given due process. So what would you like us to do in terms of a continuance or move forward?
No, I
today?
want you to settle this.
I can't settle this case. Only you can.
Well, I want to settle it.
One of the judges here on the panel, there are three of us that will be making a decision, has a question for you, or Judge Quinn.
Mr. McKissic, I'll try to explain this as simple as I can, because I understand you're not an attorney.
Yeah.
So we start with the basics, and I'm just going to use round numbers because it's the easiest thing to do. You got about $100,000 too much.
Mm-hmm.
You gave your brother about $25,000 back. So now we got you at having $75,000 too much, plus or minus.
I didn't give it to him. I loaned him some money because I was thinking. They kept telling my brother his money was in the mail.
Okay.
His money's in the mail, so I figured this was truly my money.
Okay. All right.
So
I understand that. I understand that. I'm not going to argue with you whether you thought
Right.
what you thought was true or not. I believe you when you say you thought that was your money. Okay. But
Right.
in the end, it wasn't. And so, and whether you gave your brother $25,000 for one reason or another, you gave him $25,000 plus or minus. So now you're about $75,000 too much in your pocket. It might be gone now, but that's neither here nor there. So one of the remedies that is available potentially under the law is that instead of receiving your weekly check or direct deposit of so much money per week that you get is about $700,
Yeah.
725 every week. Instead of that, you would get 80% of that, and the other 20% would be used to slowly pay back the $75,000.
Oh, the judge ruled already. I didn't have to pay none of that back.
All right. Well, she kind of did and kind of didn't, but this is an appeal and we can change her decision. So
Oh,
I'm telling you, that's one of the options available to us. So I want you to, if we think that's the way to go, the fairest way to go, so that number one, your brother can get all of his money immediately from the insurance company. And number two, you pay the insurance company back 20% of the time, about $150 a week. Is that something that you think is okay or something that you think is not okay?
yeah, that's okay. I mean, see how I was set up? They knew what they were doing. I really believe they knew what they were doing because they've been trying to get me cut off of my benefits for years. So they did this purposely. They done this purposely. They knew exactly what they were doing, and see what happens? My lawyer was a part of this too. He doesn't fight for anything. They went in there and fought to get my dental work done. Somebody is going in there taking money and doing this and that. Somebody went in there and took $11,800 some dollars for a dental payment that the dental office never received. Somebody is up to some crooked things with my case. And my lawyer, when I found the spreadsheet, he doesn't want to talk to me. He removed himself from my case.
All right. Well, I'm sorry about what happened between you and Mr. Peterson, and
I
all right, but that
yes,
issue is not in front of us. The only
okay,
issue
I
is how we can.
understand.
Okay.
This really got I'm ready to have a heart attack. I mean, this is, I'm in the hospital right now.
I understand. I don't want to cause you to have a heart attack, and I don't want to affect your blood pressure. What I want to do is see if we can craft a remedy that can help your brother and help you and help the insurance company get to a good resolution. That's what we're looking at here.
Well, I would pay them $100 and some a week. Do you know for the last, I don't know how many years, they never even give me a increase of living check? I'm at the same pay for the last 20 years. They have done me so dirty. I don't know what to do. It's like I'm just an injured worker.
Well, as to all of those issues, that is an issue for you to hopefully get a lawyer to resolve one way or the other. But we're going to deal with your brother's issue. So other than the comments you've already made, do you have anything else to add to this?
Oh man, I just, man, I'm not a lawyer. I'm not an accountant. I'm just left to this. I don't know. I don't. I pay whatever to the insurance company, even though they set me up. I'll do it, and this is wrong all the way around. This is wrong.
Mr. McKissic, I'm sorry that you've had to go through this. I know that.
I mean, I'm like, why my attorney didn't see this coming? He's supposed to know everything that's going on. Why didn't he know that these people were doing this and doing that? And in the long run, that they were going to try to take all my benefits from me. I mean, this is all wrong. I just wish I could just get all this stuff out of my life, but I don't have to deal with it no more. I
Okay.
don't have to deal with it no more.
So I just want to understand that you understand that we're here today because there's a dispute on the payment of nursing services provided by your brother to you, correct?
Yes,
And that you did receive the payment for those services as no fault of your own, but by the acts of the insurance company who put in a direct deposit of those funds into your personal account. Is that correct?
yes,
And now you understand that that payment was not to go to you, but was to go directly to your brother. And again, that's at no fault of your own, correct?
correct.
And you would be okay with a use of the statute that would allow the employer and insurer to take 20% of your payments, which are approximately $725, and recoup that money that they put into your direct account that you no longer have. Is that a fair statement?
Yes, so now I can't pay my rent, nothing.
Okay.
So because of these idiots that call themselves lawyers, they screwed up. Now I'm screwed up. You know, it's like, wow. It's like, wow, I'm just a working man that got injured at work. And because of the games that people are playing, I am still suffering. Suffering. You know, I mean, I guess I'll take it because, you know, I need my brother there for me. I don't have a wife. I don't have any kids. I need my brothers. I need them.
And I am so sorry that it had to come to this. These errors happen. They're unfortunate all around.
Yeah.
Is there anything else you'd like to say to either of the attorney, the one for your brother or the one that represents the employer, or my colleagues on this court before we close the record today?
No, I just want things. I can't even deal with it. I'm about ready to have a heart attack. That's why. Just
Well, Mr. McKissic, I'm going to close the record. We'll get a decision out within
Mhm.
90 days, and hopefully there'll be some resolution for you. Personally, I wish you well, and I hope that things will go a little more smoothly now.
Yeah, I'm still trying to find a new attorney to handle this all the wrong that's been going on. I mean, I've been treated unfairly, and I just think there's a bunch of criminal activity going on in this case where people are taking money out of accounts and accounts that just like, how do you 20 some years later, all this money is coming out and going to people that I don't know nothing about.
And I would say to you that we have limited jurisdiction. The statute's pretty clear what our job is on appeal, and I can deal with the appeal today on the nursing services. and the
Okay,
payment
all
for
right,
that.
thank you. Thank
But
you.
thank you, and I wish you well. I hope you have a speedy recovery, and I think that's it. So we'll conclude this
James,
matter.
do you want to give either of those an opportunity to respond to brother or not?
Would
don't
you
think-
like our opportunity to respond? We have your briefs and we have reviewed them. Would either of you like the opportunity to make a statement? I'm asking both the attorneys now, Mr. McKissic. Okay. Both attorneys have responded that they have nothing more to put on the record. The matter is now closed. We'll get a decision out within 90 days. Thank you all, and thank you for participating and being agreeable to make sure that we were able to get everybody involved and in the courtroom today to hear this case.
Thank you.
Appreciate it.
Well, I can hang up.
You can. Thank you, Mr. McKissic.
All right, thank you, Your Honor.